You see, because anybody that went to law school, they know about advocacy. Advocacy is one of those things that are connected to the ecclesiastical. So while you have this guy advancing this frivolous claim on one hand, and the judge having to recuse himself, meaning get up and walk away, or to find a dismissal, they still had the advocacy for the state. The advocacy is the thing that we don't understand. The advocacy is what makes them play the role of a priest. They're actually called advocates of the church. I mean, if you don't believe me, you can look it up. I went and sought out these people. I was looking at Dyfus, all of them, how they all set up through the Catholic Church, all the court systems. You have a diocesan in every state. New York and New Jersey, they share the same one. But these people are your advocacies of all states, and they vest the priestly powers, the canons, upon your judges, which turns the courtroom into a church. Remember, this is the only way that they'll be able to do the fuckery. Okay? It's straight fuckery. It's straight 666 to the ultimate. If you believe in the Antichrist and all that, this is straight it. And it is straight weak. Right? So, I want to get into it for a second. This is what makes it beautiful. Okay? Because the Ecclesiasticus says that they believe in the doctrine of grace as was established by Jesus Christ. So if you call them in their ecclesiastic capacity, they'll get up and run because they haven't been practicing the doctrine of faith. But before we go into that, because I got this for you, I want to show you how this interweaves. I want to show you. We're dealing with the interrogatories that ask, "Do you have a claim against me?" That's one question alone. That's it. In fact, I don't even have to show you anymore, because that one alone will prevent them from going to court. From going to trial. Okay. Or I'll ask another interrogatory: "Do you have an oath of office?" Now, as a statistician, you need to be wary that they will produce an oath of office. But the oath of office that they present, you will hit them under constitutional arguments. But remember, the word argument means controversy. So instead of hitting them under the constitutional oath of office, that's not the one I'm talking about. Your oath of office is from the Catholic Church. That's the one I'm talking about. He will get up and run. Okay? Strategically, I'll let him argue constitutional, by the way, as well. And as long as they don't argue constitutional, he'll say, "Yes, I have one. Do you acknowledge your role that you took to protect me?" Or, in fact, I wouldn't even come like that. I would say, "Do you have an oath of office?" Say, "Yes, I do." I say, "Well, thank God. Yo, this guy's over here. He's advancing these frivolous claims. Can you please protect me like you swore you would do? Because I got to get out of here, man." You turned it to your favor. If you say, "Oh, no, it's not that simple," then that means he's still draining the prosecutor. And that's called repugnant in the law, and that's fine, because he's still an advocate to the state, who is the Catholic Church. So there's other things you could do. But before we get into that, I'm just showing you how to lock them in, because he can't go to trial now. Because now you got this little whole cycle where you can't go nowhere, because anything you do, anytime you issue an order, you're going to go to jail. And this is for the judge. He's going to do that. I do this in real life, folks. So your Rule 33 you won't get an answer to those things before you do. Because they know I've been around here or there. And I've been around here too. They know. So, and others like me have been around. So you're not going to get a response to them, because whatever response they give is going to be illegal. And it's you being in honor and them being in dishonor. Or it's you calling them to court and them running with a warrant. Okay? He who leaves the battlefield first loses by default. That is one of those legal maxims. So if you stay up there and they run, you win. So with your Rule 33, when they don't respond, when they leave and they don't, and when they run and by default, you'll do a Rule 56, Federal Rule of Civil Procedure, Rule 56, notice of default, and you'll do that right to the clerk, and you can sue after that. You don't need all this other stuff. Just do that. You can sue for a lot. Okay. But meanwhile, you can sue and keep them stuck until they throw it out. All right, because you'll become the creature that they are. Now, the who has a claim against me is established under Federal Rules of Civil Procedure, Rule 8. 8A, 12B, failure to state a claim upon which relief can be granted is actually in 12B6 of the Federal Rules of Civil Procedure. Rule 8 deals with the forms that the complaint has to be in. You see, when they deal with you from the paperwork angle, the complaint that they have has to be set up according to the 3 prongs of Rule 8. Now, Rule 8 says that a claim for relief, or a what they call a complaint, or a what is the term that they use? A pleading. Now they call it a pleading. A pleading is nothing but a complaint. Don't go in there mean guilty, not guilty. No, they're crafty with the language. So a pleading is a complaint, and it has to state 3 things. It has to state the grounds upon which the court has its jurisdiction. It has to state the one that is making the plea and how they are entitled to relief. And it has to state that the one that is entitled to relief is seeking that the court make an order to provide that relief. If it isn't filled out, what type of relief it needs, who's entitled and how you're entitled, and why the court has a jurisdiction, it is not an official pleading for relief. Okay, so those things are never on there. It will say within the court's jurisdiction, but what does the court's jurisdiction depend upon? And it'll say, he did readily do this against the statute, but who's entitled to relief? See what I'm saying to you? Is it the cop that's writing the crime? Is it the cop that's writing the paperwork that said you did? Is he entitled to relief? No, this is called championship. It's against the law. Look it up. These are legal definitions. He's being a champion for the state. He's riding around, stirring up fake controversies, putting them in front of the state. That's against the law. Okay? So Rule 8 will allow you to do that. Okay? Now, I'm going to show you how that works. I showed you with Federal Rules of Civil Procedure. Okay? Remember, I said that there are technical procedures. I'll jump through the 3 forms of court, which is Professional Rules of Conduct, Rule 3.6. And then I did a Rule 8. I showed you how Rule 8 talks about how complaints are supposed to be. Talked about the Rule 33 interrogatory is the questions that you can ask that make them be guilty if they answer them, so they won't respond to them, which means they're running. And then you're going to put a default on them, which is the same thing they do to you, which is a warrant. And you do it with the clerk, which is the same thing they do, who give it to the sheriff. This is the process they do. Okay? And I told you who has a claim. I told you what a claim is, what it stems from, right? So all of these things are very important, because as long as you address this, you don't have to talk about jurisdiction. They have the jurisdiction, subject matter, whatever. Subject matter jurisdiction comes from having a trust in place, okay? And personal jurisdiction comes from you being right in front of them, so they have it. So I'm gonna show you how this wraps around, and then I'll bring it back to the example that Jesus did in just a few words, okay? So the next thing I want to do is I want to go over the Uniform Commercial Code, UCC 35013. All right. Now this is a demand exhibition, right? When you get a presentment, right, with these court cases they're contracts. They fall under the law of presentments. Your indictments, your discoveries, your traffic ticket, all of these things are presentments. Your electric bill, anything out here that you get, okay? These are called presentments. Now, one of the laws of presentment is UCC 3-501, Section 3. This is a type of discharge, by the way. I'll show you how, but not directly saying discharge. Because we're not talking, we got to bring this stuff into the court. We can't talk commercial because they're not talking commercial. Okay? So, it demands exhibition without dishonor for lacking a necessary endorsement. Okay? So what is the necessary endorsement that these presentments need? These presentments need an identifier. Who has a claim against me? Where are they at? You can't say it's the officer because he works for the state. You can't say it's the state, any of that. Who has a claim against me? It should be on this. Remember, look at it again. Rule 8. It talks about the Rule 8A. It talks about the complaint. 8A. Alright? Who is it? So, UCC 35013 says I can demand exhibition without dishonor. I want to see it without and still be in honor because don't forget, I'm not running. I want to see your claim. Okay? So now, under the UCC, they have to present the claim. If not, you'll take them to UCC 3-502. Okay? Dishonor happens. You see? It gets you out of contract admiralty. And into trust. They're looking for another contract work. See, because the law on discharge, I believe it's, and don't quote me on this, is discharge 3, UCC 3-603. It's B. It says that when a person is entitled to pay the instrument, they pay the instrument. It says 2 ways to affect discharge. One is by accepting it. If you accept it, it is discharge. The other way is by rejecting it. It is discharge. So there's no way you're going to lose with this approach. So what I just did was I wrapped that up into this. I wrapped it up by the Federal Rules of Civil Procedure. See, I hid the UCC. In the black lawyer, man, he warned the judge and him. He said, "This is some different type of beast, man. This is a totally different beast. He's not coming in here. He's not arguing jurisdiction. He's showing up every day. He's calling. He's doing all the loot, and we looking like idiots in front of him because we can't do them. I'm taking a prosecutor, slamming them across the floor, dragging them off, and the prosecutor, the judge is constantly picking her up. Come on, wipe it off. Okay, fine. Because I want to see if what I did really works. So I'm in here amidst these people. All right? Now, one time that I argued jurisdiction, and this is why they were scared. Because I hid it. I hid all of that behind technical procedures. Now, the thing that I did not know is that when I accused this guy's name, and when it comes to my head, I'm going to tell you his name because I'm going to oust him. Anyway, when I told this guy, when I said, yeah, he's advancing the frivolous claim, rules of professional conduct, rule 3.6, he went like a little faggot. Hey, come on, what you doing? What do you mean, motherfucker? You playing with people's lives? He's like, come on, bro. No. You see, because he just let me in on the nigga. You know how niggas do. You know how when we got something good going, a nigga try to knock that shit. You like, yo, nigga, what you doing? He did that in the courtroom, and the judge was like, just smirk like why you play your card like that? Did you not learn how to ride the goat in your Masonic lodge? It means to keep your composure through all this shit, right? Did you not learn that? So he showed me something, but I did not know at that point in time. Because all of my principles were coming off the Bible just based on the fact that I had went to law school. I had been dealing with the court system. And one day I was just in transition. I didn't have anything but a Bible. So I just started reading it without religion in it. And then I discovered the law that was going on in there. And so I learned a lot, started applying that more. And then it just really blew my mind. But I just showed you how that all wrapped in together with each other. Okay? See, these interrogatories, they're about these things, and the way you manipulate the law and turn them in like that it's like Metatron's cube. It is sacred geometry, and they are practicing magic. So, these two things, they involve law and equity under the UCC. They are guided by principles that are hidden and based in sources that they do not know. They do not know why. Well, the reason why they work is because they are taught under the doctrine of grace. This is what Jesus Christ taught. He taught the doctrine of grace. And he taught us how to get out of all of this way before it happened. So I'm going to share that with y'all now before y'all might not get a chance to have that.